Tom had this great idea that we do a legal education panel at the Technologies of Justice conference because we thought, quite glibly, legal education can be a technology for justice. Why not? You can always fit your subject matter into the conference theme, but actually thinking about the theme of technology over the past couple of days, I realized that that really is the case, and I think legal education is not only a technology of justice, but also a technology for cultivating legal consciousness, and that is really what I'm going to be talking about in my talk today. So my talk is sort of reporting on my doctoral dissertation at the University of Toronto, which was an empirical study of Canadian contract law teaching. And I interviewed 67 Canadian contract law professors in the common law provinces, plus at Faculty of Law McGill, and looked at their course syllabi and the commercial case books, looking at the messages about law and about what it means to be a lawyer that professors aspired to want to achieve, and comparing them to how they described legal reasoning and how they conceived of legal practice. And so this very technological word, operationalize, which I actually made its way into the title of my dissertation, which is even longer than the title of this presentation, if you can believe it, is really the key question, and to what extent are law professors putting into practice their aspirations for legal education. And so what I'm going to run through today is a bit of an overview of this so-called failure to operationalize some of their aspirations for legal education. So another sort of technologically oriented quote here, which really captures, I think, one of the key attitudes of law professors in my study. You do theory to help you with practice. I'm very theoretically inclined, but theory for the purpose of theory is silly. We want to know how to act in life and how to do law in life, and that's why we rely on theory and philosophy. So this notion that theory is valuable precisely because it makes better lawyers is a theme that came up again and again when I asked professors, why does it matter to talk about theory? Why does it matter to encourage people about critique? And what I want to draw a contrast between today are the substance of the theories that professors espouse to believe about law, they genuinely believe about law when they talk about law, compared to the theories about law reflected in their practices. And when I talk about practice, I mean not so much the workaday activities of an everyday lawyer, because that doesn't figure prominently in most classes. I mean predominantly the notion of thinking like a lawyer or legal reasoning. So if we think of legal reasoning itself as a practice or as a technology for the lingua franca, technology of practice among the legal profession. So that's where I'm going today. Okay, so like I said, theory, practice, how do they inform one another? First, so one very common bundle of theories is what I would call a formalist bundle of theories. So this idea that law must treat everyone equally, this is the foundation of the rule of law, that law possesses an internal coherence, and that differential results flow from making rational distinctions. So we have a coherent law that applies equally to everyone, and if similar situations get treated differently, it's because there are relevant differences, rational distinctions drawn between them. Very common, I think, element of legal reasoning that we would all be sort of familiar with. And so this idea of the rule of law, this sort of, I'm speaking extremely fast because I want to get to the contrast. So this sort of formalist bundle of commitments about law gets directly translated into this notion of legal reasoning, distinguishing, analogizing, or discerning relevance. So if we were to operationalize this formalist bundle of commitments about law, what it would look like in terms of legal reasoning are these rather familiar and I would think pretty mainstream understandings of what legal reasoning or thinking like a lawyer is. Okay. There was another, called legal reasoning or thinking like a lawyer. So there was another bundle of theoretical commitments that were quite common among the professors in my study. And this is what I would call a realist bundle of commitments. So this is the idea that all of these so-called extraneous factors, such as justice or policy or politics or context. These are the underlying desiderata or goals of law. And so law is consists of the resolution of policy decisions, or the puts into practice political decision making, or it embraces and takes into consideration broader social, historical context, and so on. And these features constitute and make up the law. This is call them a realist bundle of commitments, which I can speak quickly and in shorthand, and everyone will sort of know what I mean. So, if we were to take this realist bundle of commitments, and if we were to operationalize them, what vision of legal reasoning or the skills of a lawyer would that look like? So, for a very common one is it would produce this eclectic toolkit of persuasive reasonings. It would enable the person, when they're speaking to someone who's motivated by economic reasoning, to employ economic reasoning. When they want to make a point about fairness and winners and losers, because that would be persuasive, they could do that. They can reach into their toolkit and deploy the tool they need, another very technological metaphor, to achieve the result for their clients or whatever they're trying to accomplish. Okay, so we have a couple of professors describe this. So the most convincing argument is a combination of legal impact, policy effect, and values. The frontier between legal reasons and the other kinds of reasons is not impermeable. You can convince a court to incorporate into law the certain kinds of reasons that would not otherwise have been acceptable, right? So this is the notion that we take these extraneous reasons and deploy them in the service of making legal argument. This is what we would, this is how we would operationalize that one element of realism. Another way we would operationalize it is to think about the forward-looking planning function of, say, a solicitor. A solicitor exists to look ahead, to navigate the rocks and shoals of a given transactions, and to help the client avoid them from a prospective fashion. This is a very different type of task than simply arguing before a court. So we have one professor saying, contract is a dynamic and forward-looking mode of social ordering. There are all kinds of really good skills that are grounded in law, but are nonetheless skills. Negotiation, figuring out how much to say when and where, determining how many of a client's instructions should be acted upon, and later maybe having to convert a deliberately ambiguous or informal arrangement into codified form. This solicitor's activity. Think of Angela Swan wrote an entire case book based on the solicitor's approach. Another version of planning, not from a client's perspective, but from a more social point of view, could be the law reform mechanism. So we take this concern for politics and policy and context and use that to prospectively imagine how we would change the law on a bigger societal level. So we have Professor 17 saying, the rules really do get made. If circumstances had been different, the rules might have been developed in a completely different way. I underline arbitrariness and contingency of law to show them that if you want to change it, you have to understand those things. If we have one of the more historical case books written by James Milner, the predecessor to the Wadham's case book, he writes in his introduction, you have to know the legal system, how it works and why it works, or why it doesn't work, so that you as future law reformers may have some hope that your better ideas will be adopted. So this is one way in which this sort of realist commitment to politics, context, and policy would produce or translate or be operationalized into a vision of the lawyer as law reformer. Finally, there's this other bundle of realistic commitments sort of flowing from the notion of ethics. So someone says, I want my students to start thinking right from the beginning that they're in a profession, they have a legal and moral duty to their clients, to represent their clients' point of views. There's real lives involved here. And this notion of dignity. We have Swan writing in a very early edition to her casebook back in the late 80s. The most important aspect of any study of the law of contracts is the ability to retain a sense that law is a part of human life and that must always respect human dignity. We have to retain an almost childlike faith that things must be fair. Do not become cynical. There's too much at stake to risk the dangers of an unconcern for fairness and decency. Do not fall into the trap of thinking that it is somehow unlawyerly to be passionately concerned for justice. So this idea that we incorporate the concerns of justice into the actual act of being a lawyer is yet another vision of the ways in which realism could be directly translated into practice or directly operationalized. So we have this this notion that we can protect the public as well. Our graduates are legal thinkers. They're the ones that have to protect society from government, police, big business, from each other. That's what legal thinkers do. They're the ones that have to say the emperor has no clothes. This is what lawyers do. Lawyers take these values of the legal system and deploy them in actual practice. So here is a vision, an alternative vision to the formalist vision of how a realist bundle of theoretical commitments could be translated into quite a capacious vision of what it means to be a lawyer. Okay? And if you combine that with this sort of formalist core of conventional legal reasoning, you have quite a holistic vision of the lawyer as a citizen, you could say, a holistic vision of these various theoretical concerns that, if all operationalized, would paint quite a broad picture of what it is that the lawyer does. You could even imagine a reality in which these realist factors inform what legal reasoning is. And we start to think of legal reasoning as not simply reasoning by analogy, but incorporating these other pictures as well. So bring them all together. This is the capacious aspiration that we see among the contract law professors when you combine, on the one hand, their diverse theoretical commitments, and on the other hand, their almost consensus view that theory exists to make better lawyers. So what we should see when you ask people to describe legal reasoning, or when you ask them to model or explain what practice is or what it means to be a better lawyer, we should see a lovely image of all of this breadth and diversity. That's what we might expect if those aspirations were to be met. Okay, so deep breath, that's the aspiration. What a wonderful aspiration, integrating all this together. That's the ideal, but what is the reality? And so what I want to describe a little bit is the sort of empirical reality. The ideal was empirical in a sense, but what is the reality? What is the empirical reality? So from a theoretical point of view, I would say only about 7 out of my 67 participants I would truly characterize as champions of formalism. I call them the champions of formalism. They spoke these wonderful, eloquent articulations of the value of the rule of law and the importance of coherence and so on. By contrast, 49 out of my 67 professors I would say I would have characterized as realists in one form or another, given our conversations back and forth. And about 11 I sort of felt were sort of in between and I couldn't fully characterize. So we might expect a sort of commensurate vision of legal reasoning. And yet, when we look at the image of practice that they presented to me through their descriptions of legal reasoning, it was the opposite. There were a few people who did give me some examples, like Professor 42 of the negotiator, the forward-looking problem solver, so they weren't absent. But proportionally compared to the formalists, they were much lower proportion. The vast majority of professors, even those realists that I described, talk about legal reasoning in the sense of mastering rules, the importance of courts, and that conventional reasoning by analogy. And they over and over and over again describe these as the basics of what they have to learn as a lawyer. What do you want your students to accomplish? I want them to learn 3 things. I want them to learn the rules, I want them to learn to think like a lawyer, and I want them to do a little bit of critical thinking. But when it really came down to it, it was those first 2 that were conceived of and presented of as the basics. Okay, so great example of this is how they describe their best exam answers. The best answers are devoid of fluff. They identify the issues with some precision, and they give a tight answer that's tailored to the facts at hand. And when you see that, you sort of breathe a sigh of relief. I had one exam this year that was just so phenomenal. It was almost the perfect answer, which is quite shocking because it really just said, this is the issue, here's the analysis, these are the cases, you know? And it was perfect. It was concise, it was brief, and it was amazing. What I'm looking for is how well they're beginning to understand the rule system and how well they're able to use that rule system to create legal arguments for both the plaintiff and the defendant. What they think is a good contractual policy or what is fair or what is just or what is reasonable in the circumstances is a very difficult thing to evaluate. So if we imagine the type of way that we're incentivizing our students through our grades, how professors are conceiving of the way they evaluate the core skills they want, they are very much focusing on this sort of more formalist manifestation of legal practice. And this is well instantiated in Stephen Wadham's preface to his textbook. So Stephen Wadham's casebook, curiously, has no introduction whatsoever. But if you go to his textbook, this was written back in 1977, and he reproduces it to this day. I think it more or less captures almost the majority view among legal professors about legal reasoning. So as long as we value rationality in decision-making, we shall continue to require that like cases should be decided alike, and that there should be a rational distinction between cases that are decided differently. So this is relatively, I think, uncontroversial, describes the legal reasoning, and he goes one step further to say, I do not believe that these ends can be otherwise realized than by an impartial tribunal given reasons subject to appeal. And so it's not just this value of legal reasoning, but the emphasis on courts and adjudication and appellate judgment that we all know is the standard approach to teaching almost all law school ever since Langdalen wrote the first casebook ever on contract law in the late 1800s. So no real surprise here. Okay, so there is a few indications that we may do things differently. So this is the most commonly used casebook in Canada, the Benny, Shai, and Percy casebook. It has about 2/3 market share across the country. It was originally edited by Christine Boyle and David Percy. Christine Boyle was a feminist. She taught all throughout the country, and she, over many years, wrote this very lovingly crafted critical introduction about teaching contract law that takes us through all of the schools. And she concludes the end of the introduction and writes, so the students should realize that the emphasis on case law, especially appellate case law, is not the only way to study law and represents a particular focus which not all would accept as useful. One alternative would be to discover empirically recurring problems for contracting parties and examine the impact of the law on these problems, rather than allowing the choice of appropriate areas to be dictated by the lottery of litigation. Such an approach would concentrate on the total functioning of the law, that is, on the sociology of the law and means of social control as a mechanism for dispute resolution. So very amenable to a law and society crowd, this type of vision of what teaching contract law could look like, and follows perfectly logically from her wonderful critical introduction, which captures all those beautiful realist images that many of our law professors in Canada held. In the very next paragraph she writes, although this approach is not adopted here, our contributors preferring to concentrate on the inculcation of skills associated with more traditional materials, it is important to remember that this has significant limitations. So one reviewer has called this a curious confession and avoidance strategy on the part of the editors, and I think very much reflects, I think, some of the tension that we see in the professors themselves. So we have an early review of that edition saying the weakness of the book is precisely that the issues are raised in the introduction and not adequately integrated into the discussion of doctrine. After the introduction, these issues are either never mentioned again or mentioned in a perfunctory note. The student will quickly get the message. The study of law involves the study of cases. The rest is just gloss. It is not really law, but merely policy. So this image of the dominant message that's being conveyed through the substance is being to separate law and policy in the same way that the formalist does. And the formalist says, I'm trying to teach them juris because there's way too much prudence out there. And this is very much the sort of image of what I would say mainstream contract law teaching actually does. I'm going to end it there and just say, as a suggestive thing that we can talk about in the comments, why might this ask, and I'll talk about some of the features and sort of more structural features that might account for this sort of path dependency and dominance of formalism. We can talk about those in the questions.